Okay. Thank you, Nirvana. I think it would be great, since this is kind of our first meeting of everybody, to go ahead and do a round of introductions for the RAC members that are present today. I'll go ahead and start with department staff. So my name is Breeze Potter. I'm our water policy analyst in the director's office and also the agency's rules coordinator and integrated water resources strategy coordinator. You want to go ahead, Ivan?
Hey, good morning, everybody. Thanks for joining us. My name is Ivan Gall. I'm the division administrator for our field services division. I work out of our Salem office.
Justin?
Sure. Good morning, folks. I'm Justin Iverson. I manage the groundwater section here at the department and also based in Salem.
And then we have our lovely Nirvana Cook helping us with running the meeting here.
Thank you, Breeze. Good morning, everyone. It's really nice to see familiar faces here. I'm Nirvana Cook. I'm executive assistant to Director Tom Byler, and I am available by text or email if anyone has any technical difficulties.
Okay, perfect. Thank you. I'm going to go ahead and share my screen at this point to kind of walk through our agenda and some preliminary guidelines for this meeting. Okay, and are folks able to see full screen PowerPoint there? Perfect. So this is the first Rules Advisory Committee meeting on the Division 10 rulemaking, which is processes related to critical groundwater area establishment. So this is an overview of what our meeting is going to consist of today. We're going to take some time to review the Rules Advisory Committee guidelines, which I sent along to folks this morning. Then I will present an overview of the governing law and the draft rules. After that, we're going to transition into a draft rule review. That will be your opportunity to get into any questions and comments you may have about the draft rules. We're just going to be stepping through section by section. The RAC meeting itself is concludes at 11, and you are welcome to leave at that time if you have other responsibilities. If you are interested, you can remain to listen to any public comments or questions that we receive during the public comment period, which will be until 11:30, which is the close of the meeting today. So I would ask that you remember to treat others respectfully. If you're not speaking, please remain muted. And if you're joining by phone, you can mute by pressing *6. Also, we would ask that you use the raise hand feature to indicate you would like to speak. So if you're joining by phone, you can raise and lower your hand by pressing *9. Finally, I would like to ensure everyone receives the overview information contained in this presentation. So I would ask folks to hold their questions or comments until the rules discussion portion of the agenda if you're a RAC member, or until the public comment period if you're a member of the public listening into this meeting today. When we reach the public comment period portion of the agenda, we will determine how many minutes each person has to provide comment based upon the number of individuals who are interested in commenting. So this slide is an overview of the rulemaking process in general. Administrative rulemaking must follow the procedures of the Oregon Revised Statutes, Chapter 183, the Attorney General's Model Rules, and the Department's Division 1 rules. So the rulemaking process begins with internal development of draft rules. Then the department appoints a rulemaking advisory committee, which is you folks, comprised of persons likely to be affected by the proposed rule change. That's the step we're currently in. The RAC provides the department with feedback on the substantive language of the rules and on any fiscal impact that may result from the proposed rule change. The department will then file a notice of proposed rulemaking with the Secretary of State's office, and this includes information about the public hearing and public comment opportunities. It includes the full text of the proposed rule language and a fiscal impact statement. The Secretary of State publishes this notice in the Oregon Bulletin, that's available online, and that signals the commencement of the formal rulemaking. The department also provides notice to legislators, interested parties, the media, and the public to ensure that those impacted by the proposed rule changes are notified of their opportunity to comment either through written public comment during the public comment period or oral public comment at the public hearing. Once the public hearing is held and the public comment period closes, department staff prepare a staff report. They may make changes to the rules based on the public comment received, and then they present a rulemaking recommendation to the commission for consideration. The commission is then the ultimate decider of whether to adopt, amend, or repeal a rule. So as I mentioned, we're currently in the rule development process. The department expects to hold several RAC meetings through the beginning of next year in order to develop the draft rules for the Secretary of State notice. So after this meeting, if you could look for an email from me, I will be sending out a new poll. I know I already sent one out that included some January dates, but we have had some changes in our RAC composition since then. So I will be sending out a new one to determine the best dates for our January and February meetings. We may also meet in March, depending on how far we get through the materials in those two meetings. We anticipate the draft rules will be filed with the Secretary of State in March or April, and this will commence the public comment period. Then the department expects to consider all comments received and begin developing the final draft of the rules in May. The staff report and the recommendation to the commission would then happen at their June 2022 meeting. So now we're moving through sort of our RAC guidelines. There are some additional details in the PDF I provided you. This is kind of an overview of what is expected for those folks who have not served on a RAC before. So during the rulemaking process, the Rules Advisory Committee, or a RAC, is convened by the department in order to provide input and advice on rules before those rules are noticed in the Secretary of State Bulletin. So the RAC also helps the department to better understand the fiscal impact and cost of compliance of proposed rule changes. RAC members are selected by the department to represent a diversity of expertise, skill sets, and viewpoints. As I mentioned previously, the RAC is part of the rule development process, which is really the beginning of the rulemaking process. The RAC helps the department to consider various perspectives in order to develop rules that are fair, workable, and consistent with statute and with the state's policy goals. In this role, RAC members are not required to reach consensus or vote on any recommendations to the director and the department staff. You are expected to attend and participate fully in meetings. Please provide your perspective on issues, any concerns you have, and differing points of view in a respectful manner, and remain mindful of time constraints so that all members of the RAC have an opportunity to participate. So the department strives to conduct meetings in a manner that fosters collaboration and consensus building and ensures that all opinions are heard and considered by the group. I would encourage you, if you have any concerns about the process or any recommendations for how we can better implement and improve the rulemaking process, please don't hesitate to reach out to me or the other department staff that are present today. I would also like to remind folks that these meetings are open to the public and all RAC records are public records. That means RAC communications are not confidential. Now I'm going to shift gears a little bit and we're going to discuss the governing law and an overview of the draft rules. This is not our detailed draft rule discussion, but a high-level summary. So starting out with what is a critical groundwater area. The acronym for this is CGWA, and a critical groundwater area designation under Oregon Revised Statutes, Chapter 537, Section 730 to 742, allows the Oregon Water Resources Commission and the department to take corrective actions necessary to address groundwater supply, quality, or thermal issues. These actions may include, but are not limited to, closing the area to new uses or limiting existing uses of groundwater within the area. A critical groundwater area designation is the only groundwater control which authorizes corrective controls for curtailment of existing groundwater uses, and it's also the only groundwater control that authorizes curtailment of groundwater uses to protect senior surface water users. So the first critical groundwater area was established in 1959. Since that date, we've had 6 other critical groundwater areas. The statutes that govern this process for establishing a critical groundwater area were amended in 1991, and the department's rules, these Division 10 rules, were last updated in 1990, so they do not reflect the changes to governing law that occurred in 1991. So this is part of the reason the rulemaking is needed. The existing Division 10 rules reflect those prior statutory processes, and they do not conform with current law. So it's necessary for the department to update these rules to ensure they conform with the statutory process for designating a critical groundwater area. The proposed rules also clarify statutory terms and processes and establish a framework to guide future basin or sub-basin specific critical groundwater areas. This slide provides a general overview of the different topics that these rules address. So the purpose of the proposed Division 10 rules is to guide implementation of these critical groundwater area statutes, which is Chapter 537, Sections 730 to 742. The proposed rules will primarily focus on updates to conform to statute and will cover relevant definitions, the required criteria for critical groundwater area designations as specified by statute, the critical groundwater area rulemaking process requirements, and rule content filing and review requirements as specified by statute, the consultation process with affected local governments, the notification processes for establishing corrective control provisions, and the contested case process for corrective actions. So these rules will not create basin or sub-basin specific critical groundwater areas. They will not limit groundwater appropriation or implement corrective control provisions. The proposed Division 10 rules provide a framework for establishing future critical groundwater area designations and corrective controls consistent with statute. So once these are in place, future designations of basin or sub-basin specific critical groundwater areas will require a separate rulemaking process, which would be conducted in accordance with the provisions of these rules. So we'll be returning to the content of the proposed rules in greater detail in a moment. Now I'd like to step through the governing law of critical groundwater area designations. The statutes which relate to this are the 4 that I've mentioned before. Those are sections 730, 735, 740, and 742, which are in Chapter 537. So Section 730 authorizes the Water Resources Commission to designate an area of the state a critical groundwater area by rule. The Commission may designate a critical groundwater area if groundwater levels in the area are declining or have declined significantly, if the department finds a pattern of substantial interference between wells within the area, if the department finds a pattern of interference or potential interference between wells in the area with the production of geothermal resources from an area that is under regulation under Chapter 522 of the Oregon Revised Statutes, if the department finds a pattern of substantial interference between wells within the area and a senior surface water appropriator, or substantial interference with a restriction on surface water appropriation that has an earlier effective date. Additionally, if the available groundwater supply in the area is being or is about to be overdrawn, or if the purity of the groundwater in the area has been or reasonably may be expected to become polluted, or if groundwater temperatures in the area are expected to be, are being, or have been substantially altered. So one of these 7 criteria must be met for the Commission to designate a critical groundwater area by rule. Section 730 also requires the department to follow the normal rulemaking process, with the exception that a hearing must be held on the critical groundwater area designation at least 60 days after notice is given. Section 735 outlines the requirements for any rules designating a critical groundwater area. A critical groundwater area rule must define the boundaries of the area and contain a provision requiring periodic review of the area in order to determine its continued need. Additionally, Section 735 authorizes the Commission to include one or more corrective control provisions within the critical groundwater area rule. So these corrective control provisions, which may be included in the critical groundwater area rules, include a provision which closes the critical groundwater area to any further appropriation of groundwater, a provision determining the permissible total withdrawal of groundwater in the area, a provision that disposes of any application for a water right permit for the use of water in the area that is pending at the time the Commission initiates the rulemaking process or that is received during the rulemaking process. Any one or more provisions that make additional requirements as necessary to protect the public welfare, health, and safety in accordance with Oregon Revised Statutes, Chapter 537, Sections 505, 795, and 992. A provision closing all or part of the area to further appropriation of groundwater for its thermal characteristics, and a provision determining the permissible change in thermal characteristics of groundwater in all or part of the area. So these corrective control provisions are distinct from the corrective control provisions which are included in the final order of the Commission after the contested case proceeding. I will be talking about those in a couple of slides. Section 740 requires the Commission to file a copy of the critical groundwater area rules with the county clerk of each county which lies within the critical groundwater area, and it also requires the clerk to record the designation in the deed records of the county. Section 742 is the section that relates to the contested case processes for the critical groundwater area designation. This section authorizes the Commission to initiate a contested case proceeding to limit the use of groundwater in the area if the Commission has reason to believe any of the criteria of Section 730, subsection 1 exist, which we went over a couple of slides ago. And this step can only occur after the Commission has adopted a rule designating a critical groundwater area. Section 742 requires the Department to follow the contested case process of Oregon Revised Statutes, Chapter 183. And upon the conclusion of the contested case proceeding, and upon finding that the problems which resulted in the designation of the critical groundwater area can be resolved by implementing one or more corrective control provisions, the Commission is required to issue a final order establishing any one or more of those corrective control provisions. So this slide covers the corrective control provisions which may be included in the final order. These are the corrective control provisions that would occur after a contested case proceeding. And they could include a provision apportioning the permissible total withdrawal as established by rule under Section 730 among the groundwater appropriators in the area in accordance with relative priority dates, a provision according preference without reference to relative priorities to withdrawals for groundwater in the area for certain purposes, a provision reducing the permissible withdrawal of groundwater by any one or more appropriators or wells in the area, a provision adjusting the total permissible withdrawal of groundwater by an appropriator that has two or more wells in the area, or a provision forbidding the use of one or more wells completely, a provision requiring the abatement in whole or part or sealing of any well in the area responsible for the admission of polluting materials into the groundwater supply, or responsible for the impairment of the quality of the groundwater supply, and a provision requiring and specifying a system of rotation of use of groundwater in the area. So that is sort of the statutory framework that these rules guide the implementation of. So the proposed rules will repeal the previous rule sections and replace them with new provisions that conform to the current statutory process. The new rules are listed here, and I've broken them into two main categories. The first is new provisions that relate to the critical groundwater area rules and the rulemaking processes. And the second is new provisions that relate to critical groundwater area corrective actions and the contested case proceeding process. These next two slides will provide a high-level overview of the content of each of these proposed rule sections. And then after this presentation, as I mentioned, we will be stepping through the draft rule document itself to discuss these changes in greater detail, and so you can see what they look like on paper. The purpose of the Division 10 rules is to guide implementation of the critical groundwater area statutes, which is Chapter 537, Sections 730 to 742 that we just went over. The proposed rules incorporate the definitions from the department's Division 8 rules, which relate to statutory groundwater terms. The Division 8 rules define a number of terms which are used in the criteria for designation of a critical groundwater area under 537 Section 730, such as decline excessively, substantial or undue interference, and overdrawn. The proposed 10 rules also define additional terms which are not defined in Division 8, such as affected local government, groundwater reservoir, and water right. The proposed rules incorporate and clarify the statutorily required criteria for designation of a critical groundwater area that are contained in Chapter 537, Section 730, subsection 1. The proposed rules also provide further guidance surrounding the additional rulemaking requirements related to critical groundwater area designation rules, such as the notice requirements. Prior to holding a Rules Advisory Committee on a critical groundwater area designation rule, the department is required to consult with affected local governments and provide them with certain information to assist with the consultation. The proposed rules relating to this local government consultation incorporate the comprehensive land use planning coordination statutes and rules, and also the department's Division 5 rules which relate to compliance with statewide planning goals. Additionally, the proposed rules incorporate and clarify the content, filing, and review requirements that are outlined in statute. Sections 160 to 220 of the proposed rules are those sections that describe the contested case process. This process includes an initial notification of proposed corrective actions, which must include identification of the critical groundwater area at issue, a statement describing the factors that led to the critical groundwater area designation, a description of the proposed corrective actions, a description of the geographic area where those actions will be proposed, and a description of how persons may request a notice of proposed corrective action. The proposed rules also cover what is required to be included in the notice of proposed corrective action and the process for notification. The proposed rules provide a process for request for party status, define the scope of the contested case hearing, and describe the conduct of the contested case hearing. There's also a section which provides for exceptions to the proposed order and outlines the requirements that must be met for those exceptions to be considered. Finally, the proposed rules describe the process for issuance of a final order and what the final order may contain. So that concludes our presentation on this part. I'm going to go ahead and stop sharing my screen here. I can get back to Zoom. Here we go. And we're going to be rolling into reviewing the draft rules themselves. I don't know, Ivan, would we like to pause here for some general questions from folks before we get into the specifics?
I think that's a good idea, Breeze. If folks have general questions, maybe about the RAC process, that would probably be good to address those now before we start into some of the details of the rules themselves.
Not seeing anyone raise their hand. So I think we will go ahead and I will share up my screen with the draft rules and we can start stepping through that. Actually, just a moment here, let me get them up on the right screen. Okay. Okay, so can folks see the draft rule document pulled up here? Perfect. So as I mentioned, the department decided it would be cleanest to remove all of the prior sections and start with new section numbers for all of our new provisions, rather than sort of taking a piecemeal approach to trying to amend the existing provisions that may or may not conform, different portions of them to the current statutory framework for establishing a critical groundwater area. So for that reason, you'll see at the beginning of the document here a strike through of all of the prior Division 10 sections. So I'm going to go ahead and scroll through those to the meat of our discussion here today, which will be the new proposed language for those other sections. Sorry if I'm making anyone sick here. Let's see. Okay, so our first section here is the purpose section. This is a new rule that describes the purpose of these Division 10 rules, which is to guide implementation of the critical groundwater area statutes, which are contained in Oregon Revised Statutes 537, 730 to 742. We'll go ahead and pause there. Go ahead and raise your hand using the raise hand feature if you would like to provide any comment or have any questions about this section.
Breeze, this is JR. Where is the hand raise button?
Let me see, I'm in
JR, it's
truncated
under
version.
reactions.
Go
So
ahead.
on the bottom of your screen, there will be reactions, and then raise hand is the large bar on that.
And yeah, go ahead, JR.
Thanks. So procedural question. With this
Yeah.
delete and reinsertion, is this basically, could this be considered a full-blown reopening of the rulemaking with how you're doing this with deleting and then rewriting the full rule?
I'm not sure what you mean by a full reopening of the rulemaking.
Well, one of the things that we were informed of when we initially raised concerns about this rulemaking was that this is a very important rule, and I'll get into this in my public comments, so I won't vent. I don't think that people understand this is probably one of the most important rules in terms of people's sustainability and livelihoods in regions, in all of OWRD's rules, because it revolves around the savings account of groundwater. And we were told this would be a very tight rulemaking for specific statutory revisions. But when I saw this morning, which I want to put a note into, hopefully we can get documents with a little bit more notice to review. But when I saw this, I saw a complete deletion and rewrite, which concerns me. Does that mean that the whole document, now the whole rule is open for revision or rewriting? Because what we were informed was this is going to be a very tight rulemaking.
JR, this is Ivan. It is a complete rule rewrite in order to align the new, or what we're proposing for Division 10 rules, with that statutory change that was made back in 1991. So when that statutory change was made, the existing rules no longer conformed to the new statute. There hasn't been a critical groundwater area designation since that statutory rewrite. So this is a necessary process to prepare for future critical groundwater area designations by getting these rules updated to align with that new statute there.
From 1991?
Yeah, the statutes were changed in 1991, and since then, there has not been a critical groundwater area designation.
Mary Ann, I think you were next.
Yeah, I mean, I will echo JR's concerns, and I would appreciate, I mean, we didn't get this with nearly enough time, and I'm unclear from the intro how many more meetings we can expect to have to really walk through this, but given that you're wanting to do a total repeal and replace, I would love if there could be some side by side about what's brand new, or are we going to treat everything as brand new? And then identification of what kind of policy calls the department is making in these rulemakings, and if they're based on a case or other, the impetus for those changes. Because again, I felt like this was approached pretty casually, and you just basically like recited the statutes, which doesn't really help us focus in on where are you considering there to be policy or substantive changes. What do those mean? What are they based on? Are they based on department responses to cases? I know there's been some cases involving these statutes, I think, that you all have lost. And so I think a little less just recitation of what's going on and a little more actual information about where the policy calls are and what is new, what is just a rewording or a reworking, so that we can really focus in and give you all our perspective in the most useful way. Otherwise, I am going to have to give my perspective on every single piece of this. And I think these meetings will go for a very long time if we can't hone in on where the department's really looking for that kind of policy perspective.
So Mary Ann, if we approach maybe the next RAC meeting and try and focus in on some of where those policy calls are being made, that you'd find that helpful?
Yes, very.
Hey, Ivan, this is Mark Landauer, if I may. So this legislation was passed back in 1991, if I'm understanding. Why has it taken 30 years to update the rules?
I think from a practical perspective, Mark, it's been a function of pretty low on the priority list, given that we haven't had a need to create any new critical groundwater areas since then. That, of course, has changed. And so it's time to get these rules updated to reflect those statutory changes so we can move forward with some critical groundwater area designations.
David next, and then Drenda.
Yeah, I guess a follow-up question then for Ivan. Are you anticipating then that the existing critical groundwater area designations that occurred under the prior statutes and the old rules, are you anticipating that once these rules are in place that we'll need to revisit those existing designations, or are those kind of done and you're only looking to use these new rules to designate future areas?
The way these new rules are drafted, David, is to designate new areas. There probably is a need to revisit some of the existing critical groundwater areas. Right now, these rules as drafted don't include any language as to how to do that. So they're right now just focused on basically new area designations. So I think that's where these stand right now.
So I'm wondering, thank you. I'm wondering so this legislation was 1991. We go through this rulemaking process. Is there something on the horizon where there'd be, after 30 years, another legislative need to fix something? Or, I mean, I'd hate to go through all of this for something that's 30 years old and only to find out we're looking at a whole new process in 2023.
I think all we can say at this point is there's nothing on the legislative horizon to address critical groundwater areas and statutes that we're aware of, the department's aware of.
JR, did you have an additional question or comment?
I did. I follow up to David's question, and I'm not an attorney, but I am wanting to get a little bit more clarity around how tight that interpretation or belief is that by updating or basically, doing a full-blown rewrite of the Division 10 rules, that there's statutory provisions that don't automatically trigger or potentially lead to litigation that triggers new designations under this rule of the existing critical groundwater areas. And I don't know, I know that's your interpretation, Ivan, but I have not seen these, and I need a legal confirmation on that as we go forward, because that's a very big question and concern with the amount of investment we're putting in our region on trying to fix 4 of the existing 7.
So JR, to give me some clarity there, you're looking for legal confirmation that the Division 10 rules as drafted do not or will not impact existing critical groundwater areas?
Well, what you basically said is that this will not automatically lead to a redesignation under the new rule of critical groundwater areas that were designated under the previous rule. In the previous statute. And again, I'm not an attorney, and that seems like if there's not any clarity in statutes or something that documents that truly can't happen automatically, then I'm going to need a little bit of legal clarity around that. Because again, the department's interpreted, no offense, but that could be interpreted in a different fashion by one of the attorneys on this, one or more of the attorneys on this rules advisory committee.
So JR, if I spin your question around a little bit, would it be fair to say that you're looking for legal clarity on how existing critical groundwater area groundwater controls would be changed, or boundaries, anything that has to do with existing critical groundwater areas? What's the process about changing those? How would that be done?
Well, yes, my concern, I'll just come right out and say it, is that we have invested significant resources under the current designations and the SAYs of the current designations to move forward with a fix of those CGAs as designated. If this results in a redesignation or potentially a push to redesignate because we're now not designated under the existing rule, and that moves the goalpost on what's already an expensive and multi-biennial time-consuming effort, and we did not anticipate that coming, I want to know now that could potentially come, because it could potentially jeopardize the pathway we're taking to trying to solve our critical groundwater areas. If we have to reset and start to work with you on redesignating them under new rules and new requirements.
Okay, that helps. Thank you.
Lisa?
Yeah, I'll just chime in on this and say that, leaving aside the corrective measures, I think there probably is value in converting the ones that were designated by order into rule designations, to conform to the statute. So I agree with JR that it would be good to get clarity around that point, and how those, how the existing critical groundwater areas that were designated by order should be affected by this. And so I just agree, we need some clarification around that. And I would just put out that I think there is value in having them all done by rule as well.
Lisa and JR, let me follow up with you both on that, and there may be others that have this same concern. Would it be your preference that these rules lay out a process for changing or modifying the existing critical groundwater areas or not?
I think it would be helpful. Yes.
I'm not going to answer that today without talking with legal counsel on things. I mean, we're trying to fix things, like I've said, under the existing designations with the existing SAYs and the existing process. To take a step back now and reestablish the process and potentially have to vet out, you know, or open the door to new things that could be potentially detrimental to the effort that we're doing. I can't answer that right now without really diving into this and getting some legal advice.
That's fine. Thank you.
Yeah, no, I mean, I'll take it back to my team as well. So yeah, put that for further conversation. I mean, as far as the corrective measures, isn't there already a review process in place? So that JR, I don't think that's a new piece of it, right?
Yeah, currently, and I think Justin can speak to this in more detail than I do, but at least the last, since 2018, we've been trying to provide a review and update to our commission every 3 years on the current status of the critical groundwater areas. And it's been just that, a review of the current status. There hasn't been any proposals for changes or modifications.
We'll go with Tamara next.
Thank you. I did not see the chat function, so I'll share verbally. Is there a chat function here?
No, we don't have that for this meeting.
Okay, sometimes that just makes it more efficient. I just wanted to express my support for the suggestion that you can clarify and suss out what's in the existing rule and what needs to be changed. That's a good, that kind of crosswalk is pretty common, and that helps me understand. So again, just to support that. So what's included in the statute that's not in the rule. That's how I've served on RACs for energy and land use in the past. And then I don't know the correct time, but at some point I would like to speak in more detail about how this process complies with the OWRD state agency coordination requirement under, I think it's ORS 215, which is your state agency coordination program to comply with the statewide planning program. I think that's kind of my subject matter expertise that I'm representing on this. And on that, at this point, I don't know enough about the rule, but I wanted to check in on the process and ask, is this rulemaking committee specifically meeting that state agency coordination, the SAC coordinating requirement, or do you also have state agency staff from DLCD and LCDC on this? And that's all for me.
Tamara, I've got your questions down. I don't have an answer, but we'll get you something on that.
That sounds good. Thanks, Ivan.
Okay, do we have any more sort of general questions or statements about the rulemaking or the rulemaking process at this point from folks? Okay, not seeing any hands, so I'm going to go ahead and continue on through these rules. If you have anything come up that you think of while we're doing this, please just raise your hand and I will pause. Ivan, if you could help me monitor, just to make sure I don't miss anyone. Oh, Marianne, go ahead.
Yeah, since you're moving on to definitions, as you go through the definitions, just because it's very hard for me to toggle between screens, can you tell me which are lifted straight from the statute and which you all made any changes to, if any?
Yeah, let's see here. Ivan, I don't know if you know that offhand. I could get back to you about that, Marianne. I'll note that down.
Okay, it just, I mean, otherwise we're all gonna, I think every one of us is gonna have to duplicate that work, and it feels like, I mean, it would just be a lot easier on the review if the department could indicate what's changed from the prior rule, what's lifted from the statute, what is new, language that you all developed on your own. I think it would save us a lot of time and a lot of conversation arguing about something that might be in statute, for example.
Okay, I could definitely put together a draft rule. It sounds draft rule document. It sounds like for the next meeting that maybe has some comments dropped in the side that addresses those concerns. Anton?
Hi, morning. Thank you. Anton Kiono with the Confederated Tribes of the Umatilla. Just in anticipation of our definition discussion here, we would hope that we might see tribes reflected in any mention of affected governments, and we're certainly not seeing that here. So just wanted to pipe up with that.
Thank you, Anton. Mark?
Agreed with Anton. I'm looking at this definition. I don't think it includes certain special districts as well that have a water responsibility.
Let's go to Lisa next.
Just brief, because I pulled up 197, 190, just to look at it and see who was included, and it looks like it's been renumbered. So I don't know, again, where you got that, but it'd just be helpful if we could easily trace back the statutes.
I see Lisa Brown's hand and Drenda's hand up. Breeze.
Yeah, I think we could go with Lisa first and then Drenda.
Okay, did you say me first? Yeah, just to, I think those are good comments, but just to take a step back even further, I mean, I don't think affected local government or affected government, and correct me if I missed this, but I don't think that's a term in the statute. So I guess we would, and we'll get to that later in these rules, but we would push back on this sort of special process for any of these named entities that's in the 0140 section of these rules. So I just wanted to flag, I mean, if maybe when you do the notes that Marianne is asking for, which I think is a good idea, you could clarify where you're getting the term affected local government and sort of why it's here.
I just want to make sure we'll have the opportunity to revisit these when we get the kind of side-by-side comparison to what's current versus what's being proposed.
Yeah, Drenda, this is just the first meeting, so kind of dipping our toe in it. We know folks haven't really had a chance to review these in detail. So this is just the start of the discussion. I appreciate everyone raising some process points about how it could be improved of, our review of these draft rules. So that's exactly what we want to hear today. Thank you.
Kristen's hand is up.
Mark. Yeah, go ahead, Kristen.
Thanks. I don't want to cut off the conversation on number one. My comment is related to the second definition. And I was trying to understand why there was a need to define groundwater reservoir here. The only place that I was seeing the term used was in the new section of rules related to consultation with affected local governments. And so it felt surprising that we had another defining step in the process of identifying groundwater. So I was hoping either now or in the work that you do around the definitions, maybe you could help me to understand that. And sorry if that's obvious to everyone else. But.
Thank you, Kristen. Brenda, did you have an additional? And I think we had Mark with his hand up. Mark, did you have a comment or question?
No, it was a legacy hand. Sorry.
Okay. So do folks have any, oops, sorry, I switched our screen here. Any additional comments on that, on the definition section in general, any of these beyond what we've heard already? And recognizing we will probably be revisiting this at our next RAC meeting in greater detail. Okay. I'm gonna go ahead and scroll down then. So this section is fairly short. It is our required criteria for designation of the critical groundwater area, and this incorporates those statutory criteria of 537730 subsection 1. Looks like Sarah, you have your hand up.
Yeah, thank you. My thought was that for subsection 2, that seems like a definition of a statutory term that should probably be in the definitions section. And I also was hoping maybe you could explain the department's understanding of the meaning here, because when I read ORS 537-730 1DB, it's talking about the department finding a pattern of substantial interference between wells within the area in question, and subsection B says a restriction imposed on surface water appropriation or a minimum perennial stream flow that has an effective date earlier than the priority date of the groundwater appropriation. So when I read the proposed rule, I guess the restrictions imposed on preceding the in-stream rights doesn't make sense to me. I thought the statute was saying, you know, what the restrictions on surface water appropriation or a minimum perennial stream flow. So it made sense to me that the department saying an in-stream water right is such a restriction imposed on surface water, rather than saying a restriction imposed on in-stream water rights. I don't know if I'm explaining myself clearly, but I'm not quite understanding the meaning in subsection 2, what the restriction on the in-stream water right is, or if the in-stream water right is that restriction from the statutory term. So I guess 2 comments there, substantive, and I think it should go in the definitions.
Sarah, would you mind shooting Breeze and I an email with that, please?
Sure. Yeah, I can do that. Sorry. We've had a bit of a emergency situation. I'm a little flustered, so I don't think I'm explaining myself quite well. So I can do that.
Thank you.
Yeah.
Any other questions or comments on this section? Okay, I'm not seeing any hands raised. I'm going to go ahead and continue scrolling here. Something I forgot to mention in our definitions section is that it does incorporate, as I mentioned in the presentation, the definitions from Division 8. So I would encourage folks, if you're interested in how we're interpreting certain terms which are in the statute, to not forget to look at that section. That is important as well. And I can put together for our next RAC meeting, if you would like to have that as a separate attachment, I can include that as well. Okay, so this is section 130, which is our additional requirements for the critical groundwater area rulemaking process itself. This incorporates a number of provisions that are related to the rulemaking process, including ORS Chapter 183, which is the general rulemaking statutes, the critical groundwater area statutes, and also our Division 1 rules, which relate to rulemaking generally. In addition to those requirements, this section has some additional sort of steps for the department to take, which does include consultation with affected local governments pursuant to our Division 5 rules and the statutes which govern that land use planning coordination. Zach?
Yeah, thanks, Breeze. I'm hoping for just a clarification here. Can you tell me more about what the department thinks it means when it says consult with the affected local government? What is, I understand that I've read 0140 as well, but it's still a little unclear what the intent behind it is, what that consultation leads to.
So that would be pursuant. The process is governed both by our Division 5 rules and our state agency, I think it's coordination document. Its abbreviation is SAC, and those are approved by DLCD. I believe ours is, unfortunately, hasn't been updated since I think the 90s, but that is something that goes into this consultation process. That document and our Division 5 rules outline what happens if the department and affected local governments don't have consensus about the alignment of the rules with local plans and some additional details. So in addition to the Division 8 section, I can provide the RAC members our Division 5 and that SAC document to review before our next meeting as well.
Yeah, thank you. I would appreciate that.
I think you were next.
And sorry, I've lost a little track on what number we are. So if I'm jumping ahead, let me know, because I know Zach's question was on the local government. Mine is down on the ensure there is substantial evidence in the rulemaking record to do all of those things. And if you scroll down a smidge, I was looking at the other rule, it also says, support a determination that it will substantially impair a surface water source. I'm trying to think, and this is maybe a question for Sarah or David or some of the attorneys on the call. It feels odd to me that you are talking about putting substantial evidence into a rulemaking record when substantial evidence relates to like a contested case proceeding. And what's the relationship and effect there? That just struck me as a little bit odd. And like conflating of the contested case and rulemaking processes. She says into the void.
I apologize, Marianne. I'm trying to type your questions here, make sure I capture it. Ivan, I don't know if you want to chime in on this or if we want to circle back after the meeting.
Yeah, I'll take a quick cut at it, Marianne, and Sarah and Dave can tear into the response. So again, these rules are about how the agency would establish a critical groundwater area in the future. These rules by themselves do not establish a critical groundwater area. So for the department to come into a basin or sub-basin and say, hey, we need a critical groundwater area here, it would be nice if we base that on substantial evidence. And that's what this is getting at. If we were going to establish a critical groundwater area to control the use of pumping wells, such that they don't interfere with surface water to the point that senior surface water appropriators don't have the water that they're entitled to. I think that gets at the B there, supported the determination that a groundwater use is going to impair or unduly interfere with the surface water source. So when we come into a basin or sub-basin to establish a critical groundwater area, that will be a separate rule process. We're going to need to support that rule process with substantial evidence to establish that critical groundwater area. And that's what this is trying to get at here.
So if someone wanted to challenge the designation of the critical groundwater area, it would be would it be an 183.400 challenge to a rulemaking as opposed to a contested case challenge?
I think that's going to be correct, but I'd look to some of the other attorneys there to look at that. Real broadly, once the department establishes a new critical groundwater area through a rule process, then there's going to be an additional process, if needed, to actually control the groundwater uses within that critical groundwater area. And that would be the contested case proceeding. So the department or the commission, I'm sorry, would issue some sort of an order or draft order saying, well, we're going to control these wells in this fashion. And that would initiate the contested case hearing where everybody comes into the administrative law proceedings there with their evidence and tries to make their case.
And I see other hands, so I don't want to dominate this, but I guess my follow-up question there is, say I have a well and I disagree with you all that there is substantial interference. Would I challenge that? I mean, I guess I'd have to challenge that through the rulemaking versus the specific order to my property, because you've already made the determination that wells in my area substantially interfere with surface water in the rulemaking. And so it feels like we're changing from the current process how people would challenge in their ability, because I mean, as you're aware, it's much harder to overturn a rulemaking than it is to win a contested case proceeding. And so I feel like you're kind of raising the bar for people to disagree with the department's science on either side. And I'll maybe see what Lisa and David, and I don't know if Sarah's hands new or old, but others have to say. But I'll maybe put a pin that this is something I might have more comments on.
Thank you, Marianne. I would also, the statute cited there and where this comes from is 537780, subsection 2A, if you want to take a look at that as well. Okay, we had a couple of other hands.
Breeze, you went on mute there. We've got Sarah's hand is up, and then JR, David, and Lisa.
Sorry. Yeah, if we could go with, let's see, we haven't heard from David yet on anything. So if you want to go ahead first, David.
Sure, and I spoke up earlier on a one question. So, but I would chime in to say I agree with Marianne's concern here, and not kind of jumping ahead into the contested cases that are set up for the challenges for corrective actions inside an individual designation. I think what may help, just because substantial evidence being used in kind of this rulemaking context is a little bit unique, probably would be helpful to say up front what how you're going to define it for purposes here. And maybe it's the same as how you define it in more of a contested case setting. But I think that's maybe a little bit of what Marianne's getting at, is just if we're going to include that substantial evidence term in the rules, trying to understand what that means, what the expectation on the department is, and then if there are those that want to comment on the rulemaking or put their own evidence in, what evidence is would qualify as substantial.
Thank you, David. I appreciate that. I do have your previous comment noted. I just had forgotten. So I apologize for that. Let's go with Lisa, then JR, then Sarah.
Yeah, I guess just following up, that struck me as odd as well to have that standard in this rulemaking section. I do see that now that 2A or 782A, which oddly does refer to substantial evidence in the record for rulemaking imposing restrictions, but I guess I would just echo what David said is we need to get some clarity about when that standard applies. It seems like, yeah, when the standard applies and what it means here. And I think there's some other spots in the rules as well that had some standards cited that seemed unnecessary. So yeah, I'll turn it over to Sarah.
I can go now. Sorry, I thought JR was designated first. I don't have any additional thoughts on the substantial evidence beyond what Marianne and David already provided. I agree, but I had raised my hand similarly in this section, in section 2B. This is also pulled directly from ORS 537-730 sub 1D A and B, but this doesn't have exactly the same standard. That's what I'm concerned about. Here it says will impair, substantially interfere, or unduly interfere with a surface water source. The statute talks about a pattern of this going on rather than just a single instance, for example, and also talks about an earlier priority date water right rather than a surface water source. So I guess my concern is the difference between the statute and the proposed regulation. Thanks.
I'll be quick. I just want to echo. Actually, I feel really good because I had some of the same questions that David did. I must be as smart as him. But I am concerned about substantial. In that comment, I think there needs to be some discussion about what that means, because of other areas in this rule I've seen, there's some level of inference allowed. And so there's kind of conflicting, what is substantial versus what level of inference in the rulemaking, and where we engage potentially in that scientifically defensible discussion on establishment of the CGA before you move forward with regulations. So I think there's going to probably be quite a bit of discussion around this, I would foresee, in the upcoming months.
Thank you, JR. Do we have any additional questions or comments about this section or anything we've covered so far? Just as a time check, we have about 15 minutes left in this portion of our agenda before we move on to public comment. JR, at the beginning of the meeting, you said you had a public comment that you would like to make. I would like to make it clear to folks on the RAC that this is your time to provide us comment and feedback. And then the public comment period is for members of the public who are not members of this RAC to provide us public comment. So I would open it up to folks. I think Tamara, you had some comments you would wanted to make about the affected local government. Maybe if we could just open it up, if you have comments on any sections of the rules at this point, that you can raise those now, so I can get those noted down. And if we need to make some adjustments to the materials for the next meeting, I have some things to work on. So go ahead, Brandon.
Yeah, thanks. We've been talking a lot about critical groundwater areas, but I'm sort of wondering, how how that relates to groundwater areas of concern. And I was hoping for maybe just some comments on how those two different designations mesh with each other. and maybe what the likelihood of a groundwater area of concern might be to transitioning into a critical groundwater area. So if anyone wanted to just provide some clarity on that, I'd appreciate it.
Good question, Brandon. I'll take a cut at that and see if Justin can correct me if I'm wrong. You know, the Harney Basin, of course, was the most recent and perhaps the only groundwater area of concern that's been designated. We, I think, use that terminology. I don't know that it exists in rule or statute. And Justin, correct me if I'm wrong there. We use that terminology in the basin program rules to try and designate it as something of concern as in a straightforward manner as possible back in 2015 when we updated the basin program rules there. So I don't know that there's a direct link by the naming convention between a groundwater area of concern and a critical groundwater area, because we do have concerns, the department has, and the landowners in the basin have concerns about the groundwater level declines going on in Harney. It certainly is on the horizon for a, you know, a pending critical groundwater area designation, which would go through this process, you know, once these Division 10 rules are adopted. So I hope that helps. And Justin, correct me if I misspoke there on anything.
No, that was all correct from my understanding. Brandon, did that address your question?
Yeah, thank you.
Yeah.
Okay, Tamara?
You bet, thank you. I just wanted to follow up on my comment about coordination with the statewide land use planning program. I'm sending you an email with some more detail, but I don't see in these draft rules how this directly affects the statewide planning program, specifically OER 660 Division 23, which we know as the Goal 5 rules. And in simple terms, which is how I understand it, when OWRD designates a critical groundwater area through this formal rulemaking process, it has the effect of automatically designating that critical groundwater area as a significant resource. And in the land use world, that has significant land use impacts. And so it might be a conversation that we have maybe offline a little bit and then share it with the rest of the group. But I'm just trying, I think the crosswalk that I requested earlier would help me understand it a little bit better. And then maybe I can wrap my head around how that happens. So, and we could talk about Goal 5. So Goal 5, when a property has a Goal 5 resource, it significantly limits the land use development. So while the objective of this effort is to protect the groundwater resource, it would also have the effect of limiting what kind of development can happen on that property. So I am sending you an email with the reference to that Division 23 rule and also the state agency coordination requirement. I can tell you, for example, that the 4 critical groundwater areas that are in the Umatilla Basin, those were more or less thrust upon us, and we've never fully vetted how those are addressed in the land use plan, except reacting to that. So I would prefer that these administrative rules suss out in more detail, not just generally local government, but specifically the county and city planning offices and how that will affect the, again, the future use of the land.
Thank you, Tamara. JR?
Yeah, thanks. And again, I'll be brief. I just, in my general comments to the group, I just, as somebody that has been involved in this now for 20 years of my career, starting out, at Umatilla County, dealing with this as a Goal 5 resource, and the question of how do you fix or protect a resource that's no longer there under Goal 5, just kind of shows where we're at with rulemaking like this. But I think that I just wanted to underscore what this rule means to regions. And this rule is truly the precursor to people going broke, to land-based changes, to haves and have-nots, and to commoditization of the resource. And as such, I think this is a rule that requires that we not look at a 1 or 2 month deadline to fit a statistical game plan that we completed something. I think this deserves significant review, significant dialogue, and significant outreach prior to any recommended actions by the department or the commission. This truly is probably the biggest rule opening since Division 33 for a region like ours, and to region sustainability. And I just wanted to underscore that importance, and I appreciate the opportunity to be here. But I don't know if people truly do know the extent of what this means once this is complete, and what the implications of this are to the state. Thank you.
Thank you, JR. Do we have any additional comments or questions? We have 10 minutes left. Tamara, did you have something else, or is that a holdover hand?
Oh, sorry, gotta move it. Thanks. Hold over.
Lisa?
Yeah, I appreciate JR's comments on the importance of the rules. Another perspective is just that, you look at the Harney Basin where the groundwater is over allocated by more than 100,000 acre feet. We've seen groundwater levels dropping by more than 100 feet in some areas from the pumping. We've got domestic wells dropping, and that's of course affecting a lot of people. Obviously, there's also impacts to groundwater dependent ecosystems. So, I think we need a set of rules that can, be effectively deployed in a timely manner to address these types of situations. So, I think these rules have a long way to go to sort of lay out a clear and effective pathway. So I guess that would be my overarching comment on the rules without getting into all the subsections that we don't have time to get into now. Also, before we end this discussion, it would be helpful to have some clarity on how we should give input, like what are we doing at the next meeting type of.
David?
Yeah, just I guess as we wrap up, one other comment, again, probably for further discussion, and I think it kind of felt like we made it through 690.010.0130. But just wanted to call out subsection 5 there, and the requirement to hold a public hearing, which does relate back to the statute. And I guess, question would just be, or how to dig into it a little bit, is what exactly does that public hearing do? Is it, or what's the process supposed to result in, or could we put some just a little bit more detail around that? Because I don't know if that's simply we hold the public hearing, provide notice, and take comments, and then a decision's made, or if it's a little bit more formal than that. And this again kind of just gets back to the fact that the statute talks about pursuing as if it's a rulemaking, but then calls out that it's a little bit different because we're going to have a special hearing within the the area to be designated. So I think a little bit more detail there and what the expectations are would be probably really helpful to anybody who eventually ends up in one of these hearings.
Thank you. Any additional comments or questions? Zach?
Yeah, I'll be quick. I'll just echo part of what others have said. Breeze, that just from a process standpoint, it would be very helpful to have a better sense in advance of what sections we're going to be talking about during the next committee meeting, and when there will be opportunity to comment on specific parts of these draft rules, and also when we're going to go back and look at any revisions or changes that were made to, for example, the sections that we went over today. So just a little more process clarity would be greatly appreciated. Thank you.
Thank you, Zach. And just to answer that last part, I do not plan on making any revisions to the draft rules themselves at this time, so those will stay the same if folks have a chance to review those in greater detail before our next meeting. It sounds like from the feedback received today that it would be helpful if we had a different document that sort of walked through what was Division 10 and then what is now Division 10 and the changes. So I will be working on that before our next meeting to get out to folks. Is there anything else? I've also flagged the Division 5 rules, our SAC document, and the Division 8 rules, which are accessible on the Secretary of State website if you want to get a head start on looking at those. But I will be sending those out as well. Is there anything else that folks would find useful in their review? We have the statutory framework that's been provided, and that's those 4 ORS that relate to the critical groundwater area establishment. But I guess I would put it back on you folks of what would best help you to provide us feedback on these rules at the next meeting. Any additional thoughts or questions? Or does that all sound useful? Mary?
Yeah, I think we didn't get the materials really in time to provide enough meaningful comment. So if when you do send out the additional materials, if it could be at least maybe a week before the meeting, that would be really helpful.
Yeah, we can certainly do that, Mary. I'm hoping that this is also partly dependent on how quickly folks get back to me about the poll, but I hope to have that out, if not today, on Monday with a fairly quick turnaround so we can get the next meeting scheduled and then have our timeline for when we will need to get materials out. I appreciate that there was not a lot of time for this meeting or the informational meeting, but it was important to the department to get something stood up in this month, which is a difficult month for folks, to make sure that we are marching along on these rules and have adequate time if other items come up and we need a bit more discussion. So thank you, Mary. Any other comments or questions before we close out this portion of the meeting? Okay, we are a little ahead of schedule, but I would like to take a moment here for folks that are members of the public that would like to provide public comment in this next portion of the meeting. If you could go ahead and raise your hand so we can note down how many folks are interested and determine, how much time everyone has for that portion. And members of the RAC, you are welcome to leave at this point if you have other responsibilities, or you're welcome to stay and hear the comments from the members of the public. If you're not able to stay, we will be capturing those. So we can review that at our next RAC meeting as well.
Breeze, I'm sorry, quick question for next time. Did you want us to get you comments on the total rulemaking or just the part we've covered so far?
If you have a chance to review all the rules, that's great. I understand if folks don't. I think that we will be probably spending some time on the crosswalk document that folks have requested. But in the meantime, if you can familiarize yourself with the remainder of the rules, I know the contested case proceeding part of it is pretty meaty. So if you want to focus your attention on the first sections that have to do with the rulemaking process and the rules, I don't know that we'll get much farther than that. It sounds like, because we have some questions already raised on that section that might take some additional discussion. So if you don't have time to review all the rules, I would encourage you to at least look through those first sections. So you could leave off at section 160 through 220, which are the contested case proceedings, if you don't have the time to review those. Okay, any members of the public who are interested in providing public comment? If you could please use the raise hand feature. And if you're on the phone, the raise hand feature is *9. I don't know if we have any folks on the phone. Okay, thank you, Clay. I'll ask that you hold off for just a moment. I just want everyone who is interested in commenting to raise their hand so we can determine how long each person has to speak today. Is there anyone else who's interested in providing public comment? Okay, Clay, I guess you have the floor here.
Thank you. Clay Dumont, I'm a tribal councilman with the Klamath Tribes. And I just wanted to express our gratitude to Oregon Water Resources Department for getting started on this, early and preliminary step. We've had great concerns for some time now about groundwater depletion in our homeland. So we're eager to see this get started. And I also wanted to voice my appreciation for the Umatilla RAC members' request that tribal governments be featured prominently in the local government's language. And that's all I have to say. Thank you very much. We're watching closely here from the Klamath Tribes.
Thank you, Clay. Well, if we have no one else from the public who is interested in commenting, I would say that the RAC members can leave. I will stay on myself and WRD staff just to ensure that the public comment period remains open for those folks who might be joining late to participate in that portion of the meeting. And we will be in touch with a doodle poll for the next 2 meetings for the RAC. And if it's determined we need a third, I will be sending out an additional poll. If you have any additional suggestions, comments, anything you'd like me to know, please feel free to email me. And I will take that into consideration for our next RAC meeting agenda. So thank you, folks.
Hey, Breeze, could you quit sharing your screen so we can see the full slate of folks on the call? Thank you.
Thank you. Bye.
Thanks, Sarah.
Okay, so we are keeping this meeting open for public comment until 11:30. We have had one public comment and there was no one else at the meeting that provided public comment, but we are keeping it open in case there are any people who join late.
Thank you very much, Breeze.
I'm gonna step away for a minute, Breeze. I'll be back in a couple.
Oh, muted. Justin and Ivan, if you have other things to do, you're welcome to leave the meeting. And I can hang here with Nirvana to take any public comment that we may receive. So.
All right. Thanks so much. I saved
you.
my version of the notes to the network, so they're there for you when you need them.
Thank you.
Thank you.
Hey, Breeze. Bye, Justin. Good job with your dog. No howling so far.
I took him for a walk before this meeting to avoid that. So,
what's his name?
Augie.
Augie. Come here, Tedward. Mine have been pretty good too this morning. You know what? Maybe I'll just turn my video and mute myself, and then I'll just listen for the bell. And if anyone pops in, you'll see them on the screen. And then I'll make sure that they're here.
Okay.
All right. And then at 11:30, I'll check back in before I stop the recording.
Okay.
All right.
Breeze, I'm here if you need to take a break.
Thanks, Ivan. I'm just gonna keep this up and be off video and hang out here while I'm doing other stuff.
Okay, I'll cut loose then, and we can catch up afterwards maybe.
Okay, I'll give you a call.
Yeah, bye-bye.
Thank you, Ivan. Nirvana, if you'd like to go ahead and end the recording and end the meeting. We're at
I will.
11:30.
Can you hear me, Breeze? There I
Yep.
am. Okay,